Good evening. This is a meeting of the Athens Board of Zoning Appeals. The time is 7 p.m. and the date is June 12, 2012. At this time, I call the meeting to order. The board consists of 5 members and 2 alternates. The alternates taking full part in the discussions and becoming voting members in the absence of a member or when a member abstains for conflict of interest. Excuse me. Present tonight are Greg Lavelle, Lisa Carson, Joan Gronowski, our alternate Rick Mayer, who will be taking full part in the discussion and voting this evening, and I am Betty Howell. Our zoning administrator, John Paskey, is also here, as is our secretary, Paul Eschenbach. The board operates under the following procedure. The chair will name and describe the case. The zoning administrator will state the basis of the objection and any applicable facts or conditions pertaining to the case. The appellant or their representative will give reason why the appeal should be viewed favorably. Anyone wishing to speak in favor of the request will be heard. Anyone wishing to speak in general comment will be heard. Anyone wishing to speak in opposition will be heard. If necessary, the appellant or the representative will offer concluding summary or rebuttal remarks. Testimony from the floor will be closed. The board will deliberate and render a decision. The Athens City Code, Section 230703B, the board has power to grant variances from the strict application of the code, provided the variances will not be contrary to the public interest, the spirit of the code is observed, public safety and welfare are secured, and substantial justice is done. According to Athens City Code Section 230910C, variances from the code shall not be granted unless the board finds, based on direct, specific findings of fact, that each of the following conditions has been supported. The first one is practical difficulty and undue hardship. Because of the exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property, a literal enforcement of the regulations will result in practical difficulty or undue hardship that's unnecessary for the achievement of public purposes. The second condition is exceptional circumstances. They are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone. Preservation of equal property rights. Literal interpretation of these regulations would deprive the appellant of rights commonly enjoyed by others in the same zone and the same vicinity, while a granting of the requested variance will not convey on the applicant any special privilege that is denied to other properties in the same zone or the same vicinity. Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property. Absence of detriment. The authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purposes of the zoning code or the public interest. Not of a general nature. The condition or situation of the specific piece of property or the intended use of said property for which the variance is sought, one or the other or in combination, is not of so general or recurrent a nature as to make reasonably practicable the formulation of a general regulation for such condition or situation. I'm going to skip the next part because it doesn't apply tonight. Any person, resident, or officer, department, or appointed body of the City of Athens, aggrieved by a decision of the board, may petition the Athens County Court of Common Pleas concerning the illegality of the decision. Such petition must be filed within 30 days after the mailing of the decision of the board to the applicant. There are only 2 cases tonight. They are Case 1126B. This is a case that's been continued. It's in Zone 3 and the property is at 27 Meadow Lane. The applicant has been requesting a variance from ACC 231001A, Schedule of Bulk Controls, to allow an addition to a non-conforming structure with side setbacks of 0 feet, where 8 feet on one side and a total of 20 feet on both sides of the minimum requirements, and lot coverage of 61%, where 30% is the maximum allowed. I'm not sure that's quite it, okay, but we'll go ahead. The other case is 1205C. This is in an R1 zone. The property is at 100 Longview Heights Road. The applicant is requesting a conditional use permit to allow a private, non-commercial recreation facility where such use is under the original jurisdiction of the Board of Zoning Appeals. Okay. The board is required to take testimony under oath. So would anyone wishing to speak concerning any item on the agenda tonight please stand? Yes. Okay. All right. If you wish to speak, you should stand. Okay. Do you swear or affirm that any testimony you will present to the board will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. All right. As I said, our first case tonight is a continued case. We have already heard all of the testimony for this case at 27 Meadow Lane. So we're not going to actually rehear the testimony. We've heard that. However, I would ask Mr. Paskey or Mr. Eschenbacher, or I can briefly review the case. Would you like to do that, Mr. Eschenbacher?
Well, it might actually be better. I know it'll take a couple minutes, but it'd probably be better if I kind of read generally from the minutes here. Chairperson called on the zoning administrator to testify. The zoning administrator read aloud memos from City Law Director Patrick Lang indicating the right of the Board of Zoning Appeals to hear this case. At that meeting, Ms. Towsley asked what powers a neighborhood association may have in this case. The zoning administrator said that there is no official neighborhood association for the Meadow Lane condominiums. The chairperson called on the appellant to testify. That was Bill Walker of 211 Columbus Road, who was the appellant's representative. Mr. Walker challenged the denial of the project based on bulk controls, as he contended that this is a planned unit development, or PUD, and bulk controls do not apply. Mr. Walker said that the project would not encroach into the backyard and would be within the current building footprint. He also noted that the proposed roof line of this project would not extend beyond the existing roof line. Mr. Walker then referenced a list of other building and remodeling projects done on Meadow Lane in the last 30 years. Mr. Walker noted that a petition of opposition had been submitted to the board and he wanted to respond to that. Mr. Walker noted several Meadow Lane addresses where either permits had been granted for additions or no permits had been submitted. Ms. Kronansky asked about porch steps for the project. Scott Brooks, who is the proposed contractor for the project, said that there is an existing lower deck there. The zoning administrator said that that part of the project submitted was to remove the lower deck as the upper deck was approved. Mr. Mayor asked about the section of the PUD plan that says if the condominium is destroyed, it could only be replaced on the same footprint. Mr. Walker said if that happened, the owner may have to go back to the original footprint, but that the possibility of the condo being destroyed is not germane to the current variance request. Chairperson called on anyone wanting to speak in favor of the variance request or make general comment. No one came forward. The chairperson called on anyone wanting to speak against the variance. Abby Lavelle of 2 Meadow Lane addressed the board. Ms. Lavelle noted that she purchased her condominium as it exists and the porch was already enclosed. She also said that she owns 25 Meadow Lane and did not add on to it. She also noted that her father lives there. Ms. Lavelle presented photographs and documents about the property in question. She stated that the proposed addition will block sunlight to the windows at her father's condominium. She also noted that 27 Meadow Lane has 2 full bathrooms, not 1 1/2 bathrooms as the appellant. Ms. Lavelle said that the condominium has an extensive back deck and a backyard that is supposed to be green space but is not. She said the proposed addition will negatively affect 29 Meadow Lane as it will block the side view and restrict airflow and light. She said she believes the project may expose structural problems and will decrease property values. Ms. Lavelle said this variance request is a luxury request and no other Meadow Lane condominiums have extended their second floors. Ms. Lavelle also referenced a letter submitted by Joanne Larson of 7 Meadow Lane objecting to the project. Ann Santa, who is the owner of 5, 9, 12, 14, 23, 24, and 28 Meadow Lane, addressed the board. She said that she supports the objection to the variance. Gail Berenson of 3 Meadow Lane addressed the board. Ms. Berenson said that when she wanted to enclose her deck, she went to the developer to ask and made no outside change to her condominium. The chairperson then called on the appellant for rebuttal. Ahmed Faik addressed the board. Mr. Faik said that Ms. Lavelle's term of luxury was wrong and that he needs space to have a relative come live with him. He said that there had been a previous approval for the deck. He also indicated that the first floor bathroom has a shower, not a tub. Mr. Faik said that it was not true that his addition would block sunlight and referenced photographs and diagrams indicating sunlight patterns at the site. He said that 27 Meadow Lane will receive less sunlight than his neighbors. The chairperson closed the floor for discussion. Ms. Towsley at the last meeting noted that the variance request would not be necessary if the developer had signed off on the project. The zoning administrator said that the developer of the Meadow Lane condominiums, under the approved PUD, had power to approve or deny changes in the units for 20 years, and then, if not turned over by the developer, another term of 10 years, and recurring thereafter, if not turned over. He said the developer still has a say if he does not take himself off the deed. The zoning administrator said that the developer, Bruce Wentworth, told him that he would abide by whatever decision the board makes concerning the variance. Mr. Lavelle and Mr. Mayer said that they had nothing in writing to confirm what Mr. Wentworth said. The chairperson suggested that the board go ahead with the case, but on a motion by Mr. Lavelle, seconded by Mr. Mayer, the board considered to table case 1126 until further information can be obtained from the developer. The vote was 3-2 yes, so the case was tabled. And we were given instructions to get a letter from the developer, Bruce Wentworth, which I believe I gave you all copies of. The undersigned, Bruce K. Wentworth and John Soule, being first duly sworn, deposed, and state as follows. 1, we are the sole owners, president and secretary respectively, and duly authorized agents of Soule Wentworth Incorporated. Number 2, on August 28, 1981, we executed and recorded on behalf of Soule Wentworth Incorporated a declaration of covenants, easements, and restrictions for a 34 townhouse development as recorded on September 2, 1981 in volume 366, page 437 of the Athens County Recorder's Deed Records. Number 3, as part of the above referenced declarations, paragraph B5 provided that Soule Wentworth Incorporated retain the right as the developer to approve alterations or exterior additions. Number 4, Soule Wentworth Incorporated no longer owns any interest in the above referenced property and as such no longer wishes to exercise jurisdiction over the approval of alterations or exterior additions in the development as the developer. All future alterations or exterior additions shall be deemed to be approved by the developer so long as they conform with the laws, ordinances, and other regulations as set forth by the City of Athens.
Thank you very much. We are at the point where we were at the last meeting, where we're going to go through the findings, unless you have some comments you want to make before we go through the findings. Any further discussion?
No comments.
The one thing I noted is it said that the extension would not expand or extend the roof line, but the second floor addition, it appears, would in fact extend the upper roof line. It would have to.
That is
Right.
true,
Yeah.
and I think Mr. Paskey alluded to that last
Right.
time, so that clarifies the discrepancy in what seemed to be there. Anybody else got a comment before we go through the findings? Okay, then let us take them up. The first thing we have to consider is practical difficulty and undue hardship.
We need an official
Yes, we
motion.
do. Yes, I frequently forget that. Could we have a motion about this?
Yeah, I move the board consider request for a variance for 27 Meadow Lane, Ahmad Faik, appellant, from Athens City Code 2310-01A, Schedule of All Controls to allow an addition to a non-conforming structure with side setbacks of 0 feet where 8 feet on one side and total of 20 feet on both sides are the minimum requirements, and lot coverage of 61% where 30% is the minimum allowed. This case is, we don't need that.
Okay, second to this motion?
I second.
Okay, thank you. So as I said, the first thing to consider is the practical difficulty. And again, this is a condition that we sometimes struggle with a tiny little bit. it says, because of exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property, a literal enforcement would result in practical difficulty or undue hardship that's unnecessary to the achievement of public purposes. So, what do you have to say about that?
Well, under the circumstances, the way these structures were built, similar to row houses, with the intent of residents living there with small backyards, it just seems to me that I just don't see the practical difficulty of the property if the property is already established as such.
Okay. So, but it's not the practical difficulty to the property, I don't think. It would be
It's-
to the owner who would suffer undue hardship.
Well,
because-
it's practical difficulty of the property and undue hardship of
That's right.
use. So
That's right. Okay.
in terms of then undue hardship,
Would it be an undue hardship to have to forego a larger upstairs bathroom?
well, there's 2 bathrooms there already.
Okay, all right. And is there something extraordinary about this property that doesn't apply to the other properties?
Not that I can see.
Okay, so that
Not
takes
that
us
I've
to
heard.
exceptional circumstances. There are exceptional or extraordinary circumstances or conditions applying to the property in question or its intended use that do not apply generally to the other properties or classes or uses in the same zone. The properties were all built pretty much the same, so I don't see how you can say that there's something extraordinary applying to this one, but that is my opinion.
Agreed.
Yes.
I agree with that.
Okay. The third thing is preservation of equal property rights. A literal interpretation of these regulations would deprive the appellant of rights commonly enjoyed by others in the same zone and the same vicinity, while a granting of the requested variance will not confer on the applicant any special privilege that's denied to other properties in the same zone.
Well, many of the other property owners have various porches that were covered or small extensions, but nobody's gone up.
Right.
And I think that is the
the same
deviation,
level. Okay.
correct.
All right.
So
Okay.
then that would be a special privilege.
Okay, and here's one that seems important to me, and it's minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property.
I don't think that's been shown.
Okay. Because,
I guess because the neighbors have the similar properties and they consider their use to be reasonable, I guess.
okay, all right, so he is in fact making a reasonable use of the property already. Absence of detriment, the authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purpose of the zoning code or the public interest.
Well, I think there was enough comment that the adjacent property owners were displeased, particularly that I thought was important was to go up an additional flight, and if you looked at the window on the house next door, it would appear that you would block part of the view with that. So I believe that that would be the only detriment that would affect my decision.
Well, I also think that even though Sol and Wentworth have signed off on this and agreed to abide by whatever whatever we decide, I think a number of people did express their opinion that said that they had bought their property understanding that these covenants were in place, and they had no idea that they would, in time, perhaps disappear and the property become more diverse than it had been. The last one is not of a general nature. The condition or situation of a specific piece of property is not of so general or recurrent in nature as to make reasonably practicable the formulation of a general regulation for such condition, and I think clearly the answer there is no. Okay. So, are you ready to vote? We'll start with Mr. Mayor.
No.
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 And I also vote no. So, we're ready for the next case. Okay. And this case is at 100 Longview Heights Road. The appellant is requesting a conditional use permit to allow a private, non-commercial recreation facility where such use is under the general jurisdiction of our board. Okay. So who is going to speak to this issue tonight? Okay. Would you come forward? Well, let's see if Mr. Eschenbacher wants to say something first.
I did want to present to the board one added piece of that for you to look at. It's too big for us to make copies of it. But these are plans for the building on site and also building on site.
And I can speak to the project. It's basically a cabin on numerous acres up on Longview Heights that Boy Scouts and Girl Scouts use, owned by the Rotary. And they had an addition, or have an addition, on the rear of the building that was dilapidated, falling down, etc., that they use for storage, kind of a makeshift kitchen, etc. And their request is basically to tear that down and rebuild it a little differently, as you can see there on the prints. But that's the gist of the project.
Okay. So just tell me again, they're tearing that off and putting on a new...
They're the rear part of the existing house. And according to 230401C1 of our code, they've done enough work that triggered it to come before you today. And if I can find that, I'll read it for you here. It is zoned R1 up there, and it is a conditionally permitted use. The following uses shall be permitted only if expressly authorized by the Board of Zoning Appeals in accordance with provisions of this code. It's Title or Section 1, recreational, private, non-commercial recreation areas and facilities not listed above, which listed above were recreational, public parks, playgrounds, etc. So it is a permissible use, or I should say a conditionally permitted use. Therefore, with the BZA's permission to do so. And then under the conditionally permitted uses for your actions are general provisions. The BZA may authorize the issuance of a conditional use permit in accordance with the following provisions. 1, conditional uses for which a permit is issued are permitted in the zone. 2, each additional use is considered as an individual case. 3, the BZA shall find that the case conforms to the specific requirements enumerated in each section and also these standards. The conditional use complies with all applicable city regulations. The conditional use will be of such location, size, and character that it will generally be in harmony with the appropriate and orderly development of the zone. It will not be detrimental to the orderly development of the adjacent properties, nor inconsistent with the city comprehensive plan. And 3, the ingress and egress from the parking area is so designated as to cause minimum interference with traffic on abutting streets. So those are the 3 issues I believe you need to look at.
Okay.
In your decision.
Okay, Mr. Wentworth, will you give us your name and address when you get to the podium?
Yeah, my name is Bruce Wentworth, 8266 Rock Riffle Road, and I'm in the in Athens Noon Rotary. Basically, the project is an attempt on our part. We've owned the property, I think, since 1980. This cabin was built in 1934. Basically, was built for the Girl Scouts, and it has been used over the years for use by specifically Boy Scouts, Eagle Scout projects, Girl Scouts, kind of campouts, nature visits, basically that kind of youth camp kind of thing. It's been around for as long as anybody I know can remember.
Right.
And we are asking to do nothing. I mean, we're basically renovating the dilapidated kitchen, which is literally falling off the building. with the help of groups from Hocking College and Ohio University and committees within Rotary, we are in the process of completely, fixing bridges down there, walkways, really improving the property. There had been some complaints about property kind of deteriorating a bit, and this big push was on to improve the property, and one of the ideas was to get rid of the existing kitchen and build the addition that you see there, and that would also include a separate bathroom area that's a chemical toilet, needs no water, no waste issue at all, and that's the proposal.
Okay, thank you very much. Anybody got questions before we sit?
Well, I guess my one question would be, because you can't tell from the drawings that we had, is, I'm assuming that building is at least 40 feet from any, I mean, you look on the map and it goes to the one edge, so is it, or?
Yeah, you can't really find it unless you kind of know where it is. I mean, it's definitely, I think it's 150 feet from the nearest property line.
Other questions?
Is this really this isn't really a change in use, it's been in use as a non-commercial recreational area
No
for,
change in use.
since prior to 1934, even when the Rotary initially owned the property.
Right, and no change in use at all, just the idea was to create, the cabin itself is in really great shape, but like I said, the kitchen was disgusting, and the idea was to create this bright new facility there, so to complement the cabin and therefore making more groups want to use it. And the way we work that is that if someone uses it, they commit to helping us out with a little bit of maintenance. That's kind of the payback. More people that use it, the more people we have feel attached to it and feel a part of it, and just the better it gets. So that's the reason for doing this.
Coming from a law enforcement perspective, one of my biggest concern would be currently the city has alcohol-free areas such as the West State Street Fields and down on Richland Avenue. My concern is being in a remote location like that pretty much is, if alcohol is allowed into that area, it could create some enforcement issues for local police departments.
Yeah, now, I don't know if it's specifically prohibited, but I know that it's very implied that that's the case. I mean, you don't usually bring beer to, Cub Scouts don't bring beer down there, and, I mean, if there are other groups that go down there for that purpose, they really aren't, they're not supposed to be there. That's the whole idea. We're in the process of doing a new gate up front with some security, maybe possibly some security cameras. There's an electric service down there, so we are attempting to really upgrade the whole property, and that would include, if necessary, surveillance issues.
So there wouldn't be any problem with a condition on a use variance that would indicate that it'd be treated the same as the West State Street Fields and other city property as to being non-alcohol.
Yeah, no, I don't know what the legalities would be of specifically writing that into some restriction somewhere. It's just, my understanding is that that's definitely always been implied. I don't know if it is written somewhere.
Okay.
Okay?
Okay. Anything else? Is that something you all think we should address, or you think the Rotary Club should simply address
I
it?
think they need to do that since it is private property. I don't
Okay.
know if we can. You probably know better than I do.
Okay, so we assume that the Rotary Club is responsible enough to make it clear to the people using it that it's an alcohol-free area?
Well, that's always been the case.
Sure, okay. All right. Anything
There's
else?
also the provision that, heaven forbid, you grant the condition and there turns out to be problems
Yes,
at the campsite
right.
due to alcohol or anything else, of course, you can revisit this and see if it's worth keeping conditional use.
I think it's beneficial to have that condition in there, that it be treated the same as the Athens City recreational areas are treated. I believe the mayor has to approve the use of alcohol even at the community center.
How do you feel about that?
Well, as long as they were able to, if they had some kind of special event that alcohol was going to be there, that someone could approve it as opposed to never, ever. So as long as there's a body or a person that does have approval.
Those sort of things come across my desk every day. So if they were wanting to do something like that, then they would have to make a formal request, and it would come across my desk.
Okay.
As far as
And
that
then
goes.
what do you normally do?
All I do is verify, it's the form liquor control, the state liquor board sends to us wanting to know what year the project was annexed into the city limits, and then they do their investigation from there and issue, they're the ones that issued a permit for alcohol. And I believe, I can't remember if city council has approved it too, I can't remember.
So is it a lengthy approval process?
I get the stuff sometimes 2 weeks in advance, so it must not be.
Okay. Yeah, I'd like to see that then as a condition.
Okay.
But that's a requirement throughout the
Okay,
city.
so what you're saying, that if the Rotary Club itself wanted to have a function there with spouses and guests and so forth,
And they were selling alcohol,
And you-
they would be required to
or
obtain a
if people
permit.
brought their own
It
alcohol.
wouldn't be a case of selling, but just for instance, if we finish this project and we decide to have a celebration and open a bottle of champagne because we put all this hard work into it,
Sure.
it would be a shame if we were unable to do that. The same as having a function at the community center where people drink
Yes,
on occasion.
okay.
But that would be a great, because basically it's alcohol-free unless there's some sanctioned event that is approved.
I think 3A of the city code takes care of the situation. The conditional use complies with all applicable city regulations. That would be included.
Yeah, oh, okay.
Okay.
Is selling of
So you're
alcohol.
looking at 230703A?
I'm looking at 2307,
Okay. The conditional use complies with all...
3A.
Okay. E3A is what you're looking at?
Yes, and
Okay.
I think you need to vote on all three of those conditions,
Okay.
3A, 3B, and 3C. You know,
Okay.
discuss them like you would your findings.
All right. All right, so, anything else you want to say before we have a motion? We need a motion.
I move we grant a variance in case 12-05C, 100 Longview Heights Road, Zone R1, appellant Athens Rotary Club. The appellant is requesting a conditional use permit to allow a private non-commercial recreational facility where such use is under the original jurisdiction of the Board of Zoning Appeals.
Second.
Okay. All right, as Mr. Pesky has pointed out, these are the things we should consider. It's on page 24 of the zoning code. We're looking at E, conditionally permitted uses. We can authorize a conditional use permit in accordance with the following provisions. Conditional uses for which a permit is issued are permitted in the zone. And you've already told us that it is permitted in this R1
Yes,
zone
that
as
is
a park
correct.
or recreational area. Each conditional use is considered as an individual case, so if there are other things that come before us, they will be considered separately, apart from what we're doing here tonight.
Correct.
Okay. The BZA shall find that the case conforms to the specific requirements enumerated in each section and also these standards. Okay. 3A is the conditional use complies with all applicable city regulations. And I'm hoping that
Yes, we're asking that
satisfies your
it do
concern.
so.
I think so.
Okay. B, the conditional use will be of such location, size, and character that it will be generally in harmony with the appropriate and orderly development of the zone. It will not be detrimental to the orderly development of adjacent properties, nor inconsistent with the city comprehensive plan. And as we've already said, it is a permitted use. It was there long before Longview Heights was developed, except for a few farmhouses, perhaps. So I think it is in harmony to have a recreation area and a park in an R1 zone. It's really quite nice to do that. And the last one is C, the ingress and egress from the parking area is so designed as to cause minimum interference with traffic on abutting streets. I don't think there's any problem there, is there?
I believe there's only one entrance to the place, which in my mind makes it
And most of the
minimum.
Cub Scouts and Girl Scouts don't drive, so,
And it's a small parking lot.
okay. All right, so Greg, shall we start with you to vote?
I vote in favor of.
I also, yes.
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 And I also vote yes, so great. Hope you have a lovely kitchen. Invite us to the celebration.
Oh.
Okay, other business for us?
Yes, before we dismiss tonight, was it the last meeting, or 2 meetings ago, the Blue Gator project, 63 North Court Street, we granted variances for side yard, front, I can't remember, the parking, et cetera, et cetera. We failed or omitted to include the rear yard setback. I didn't know if it should have been on our list, and it was required. It's only like 7 feet is all they have, so that should have been on there.
Okay,
I guess, I didn't know if we could just vote on that now and add it and make an amendment to it, that be
To the
included. We did
original
discuss
variance?
this at the planning commission, that I would ask the board of zoning appeals if we could just make an amendment to it being approved.
Yeah, I think, but it might be actually better to do it at the next meeting. That way we can get the information and
Okay.
give you time to
That would be
review the
good.
minutes and
Okay.
all that.
thank you.
That
That
would
would probably be better, right.
Just
So-
something to think about.
All right, okay. Has somebody read the minutes and thinks we should approve them?
I have, and yes, I do.
All right,
I'll second.
all right, all in favor?
Aye.
Anything else for the good of the order?
I was just going to say, that it might be in those minutes.
Okay, we
We
adjourn.
might have them